Trick questions cops ask at DWI stops. Flashlights in your eyes. They're blue lights in your rearview mirror. And the very first friendly question the officer asks you is collecting evidence to pin a North Carolina DWI on you. Answer wrong and you're staring at a suspended license, 4-figure fines, and a criminal record that follows every job application on your file. Stay here, I'm about to break down each hidden trap question and the exact legal one-liners that shut them down before they ever reach a courtroom. When you're pulled over for a suspected DWI in North Carolina, you need to understand that everything changes the moment those blue lights flash behind you. The officer isn't just making conversation with you. Every single question they ask has a purpose, and that purpose is to gather evidence that can be used against you in the courtroom. Hi, I'm DWI attorney J. Scott Smith, and I've been defending people charged with DWI in North Carolina for over 18 years, and I can tell you that most people have no idea how these stops actually work. They think if they're polite and cooperative, everything will be fine. But here's the reality. By the time those lights are flashing, the officer already suspects you of driving while impaired. They're not trying to figure out if you're impaired, they're trying to prove it. Police officers receive extensive training on DWI detection and investigation. They learn specific questioning techniques designed to elicit incriminating responses. These aren't random questions. They're carefully crafted to make you say things that'll hurt your case later. The officer might seem friendly, even sympathetic, but remember, they're doing their job, and their job is to build a case against you. The questions they ask serve multiple purposes. First, they're listening to how you speak. Are you slurring your words? Are you speaking too slowly or too quickly? Are you confused or having trouble understanding simple questions? Second, they're trying to get you to admit to drinking or using substances. And third, they're looking for you to make inconsistent statements they can use against you later. Under North Carolina law, specifically North Carolina General Statute 20-16.2, officers have broad authority to investigate suspected impaired driving. But here's what many people don't realize. You have rights during these stops, and understanding these trick questions is the first step in protecting those rights. The classic opening question. Where are you coming from? This seems innocent enough, doesn't it? The officer walks up to your window and after asking for your license and registration, they casually ask, so where are you coming from tonight? It sounds like small talk, but it's not. This question is designed to get you talking about your evening. The officer wants to know if you've been at a bar, a restaurant, a party, or any location where alcohol might be consumed. They're hoping you'll voluntarily provide information about your activities that evening. If you say you're coming from a restaurant, they'll follow up with questions like, what did you have to eat or drink? If you mention a friend's house, they'll ask about what you were doing there. Here's the trap. Many people think that being honest will help them. They say something like, I was at dinner with friends at Applebee's. Now the officer knows that you're at a location that serves alcohol. They'll follow up with, did you have anything to drink with dinner? And now you're in a difficult position. If you say no, but they find evidence that you did drink, you've lied to a police officer. If you say yes, you've just admitted to consuming alcohol before driving. I've seen cases where people tried to minimize their drinking by saying things like, I just had one beer with dinner. What they don't realize is that this statement can be used against them in multiple ways. First, it's an admission that they consumed alcohol before driving. Second, if their blood alcohol content comes back higher than that one beer would typically produce, the prosecution can argue they were lying about the amount that they consumed, which damages their credibility. The smart response to this question is to politely decline to answer. You can say something like, Officer, I'd prefer to exercise my right to remain silent. This isn't suspicious or unusual. It's a constitutional right, and you're allowed to use it. The drinking question, how much have you had to drink tonight? This is probably the most obvious trap question, but you'd be amazed at how many people fall for it. The officer will ask directly, how much have you had to drink tonight? Or, have you been drinking tonight? Let me be absolutely clear about this. There's no good answer to this question. None. If you say you haven't been drinking and they later find evidence that you have, you've now added lying to a police officer to your potential DWI charge. If you admit to drinking, you've just provided them with direct evidence that you consumed alcohol before driving. Some people think that they can thread the needle by admitting to a small amount of drinking. They'll say something like, I had 2 beers earlier, or I had a glass of wine with dinner. This is a mistake for several reasons. First, you're admitting to drinking before driving. Second, if your blood alcohol content is higher than what those drinks typically produce, the prosecution will argue that you're lying about the amount. Third, even if your blood alcohol content is consistent with what you claim to have drank, you're still admitted to drinking before driving, which supports the DWI charge. The prosecution doesn't need to prove that you were drunk. In North Carolina, they only need to prove that you were appreciably impaired or that your blood alcohol content was 0.08 or higher. Admitting any amount of drinking helps them to establish both of these elements. I've handled cases where people admitted to having just one beer and still got convicted of DWI. The prosecution argued that even one beer combined with the other evidence showed that the defendant was appreciably impaired. The jury agreed. The timeline trap. What time did you start drinking? That question often comes in after you've already admitted to drinking. The officer will ask, "What time did you start drinking?" or "When did you have your last drink?" This might seem like a straightforward question, but it's actually a sophisticated trap. The officer's trying to establish a timeline for your drinking. They want to know when you started, when you stopped, and how much you consumed over that time period. This information allows them to calculate your estimated blood alcohol content at the time of driving, using something called retrograde extrapolation. Here's how this works. Alcohol is absorbed into your bloodstream at a relatively predictable rate, and it's eliminated from your body at a predictable rate also. By knowing when you started drinking, when you stopped, and how much you consumed, and when you were driving, an expert can estimate what your blood alcohol content was at the time of driving. The problem is that these calculations are based on averages, and individual results can vary significantly. Factors like weight, gender, food consumptions, medications, and individual metabolism all affect how your body processes alcohol. But prosecutors love these calculations because they seem to be scientific and precise to juries. I've seen cases where people gave the officer a timeline of their drinking, and the prosecution used that information to argue that their blood alcohol content was even higher at the time of driving than it was when they were tested hours later. This is called rising blood alcohol, and it's a common prosecution theory in DWI cases. Even if you think that the timeline helps you, it usually doesn't. Let's say you tell the officer that you had your last drink at 8 p.m. and you were pulled over at 10 p.m. You might think that this shows that you had time to sober up, but the prosecution can argue that your blood alcohol was still rising at the time of driving, meaning you were actually more impaired while driving than you were when tested. The sobriety question. Do you feel like you're okay to drive? This question is particularly insidious because it sounds like the officer is giving you a chance to be honest about your condition. They'll ask something like, "Do you feel like you're okay to drive? Or do you feel impaired right now?" This is a classic damned if you do, damned if you don't question. If you say you feel fine to drive, the officer can argue that you showed poor judgment because you were clearly impaired but didn't recognize it. If you say you don't feel okay to drive, you've just admitted to driving while impaired. The question is designed to make you evaluate your own impairment, and there's no way to answer it that helps your case. If you say you feel fine, but the officer observes signs of impairment, they can testify that you lack the judgment to accurately assess your own condition. This actually supports their case because it shows that your mental faculties are compromised. If you express any doubt about your ability to drive, you've essentially confessed to the crime. The prosecution will use your own words against you to prove that you knew that you were impaired, but chose to drive anyway. I've seen officers ask this question in different ways to try to get people to incriminate themselves. They might say, "On a scale of 1 to 10, how impaired do you feel?" Or, "Are you sure you're safe to drive?" No matter how they phrase it, the question is designed to get you to make statements about your impairment that can be used against you. The medication question. Are you taking any medications? This question often catches people off guard because it seems medical rather than legal. The officer will ask, "Are you taking any medications?" or "Are you on any prescription drugs?" What many people don't realize is that DWI in North Carolina doesn't just apply to alcohol. NC General Statute 20-138.1 makes it illegal to drive while under the influence of any impairing substance, including prescription medications. The officer is trying to determine if you consumed any substances that can impair your driving. If you answer this question, you're potentially providing evidence that can be used against you. If you're taking prescription medications that can cause impairment, admitting to taking them can support a DWI charge even if you haven't been drinking alcohol. The tricky part is that many common medications can potentially impair driving. Antihistamines, sleep aids, anxiety medications, pain medications, and even some blood pressure medications affect your driving ability. The officer doesn't need to prove that you were impaired by these medications, just that you were impaired while driving and had these substances in your system. Some people think that they're being helpful by explaining their medications in detail. They'll say things like, "I'm on Xanax for anxiety, but I take it as needed," or "I have a prescription for Percocet, but I only took one this morning." These statements can be devastating to your case because they establish that you consumed impairing substances before driving. Even if you're taking medications exactly as prescribed, you can still be charged with DWI if those medications impair your driving. The law doesn't provide an exception for prescription medications taken as directed. The performance question. Would you be willing to take some tests? When the officer asks if you'd be willing to take some tests, they're referring to field sobriety tests. These are physical and mental exercises designed to detect impairment. The officer will usually present this as a way for you to prove you're not impaired. This is misleading for several reasons. First, field sobriety tests are designed to detect impairment, not prove sobriety. They're looking for signs that you're impaired, not evidence that you're sober. Second, these tests are subjective. The officer decides whether you pass or fail based on their observations and training. Third, these tests can be failed by people who are completely sober for a variety of reasons. The standardized field sobriety tests include the horizontal gaze nystagmus, or HGN test, the walk and turn test, and the one-leg stand test. These tests were developed by the National Highway Traffic and Safety Administration, or NHTSA, and are supposed to be administered in a specific way under specific conditions. However, roadside conditions are often far from ideal. I've seen people fail these tests because they were nervous, because they had medical conditions, because they were wearing inappropriate shoes, because the testing surface was uneven, or because the officer didn't administer the test correctly. The tests are also difficult for people who are overweight, elderly, or have balance problems for reasons unrelated to impairment. The important thing to understand is that in North Carolina, you're not required to take field sobriety tests. These are voluntary, and you can politely decline. The officer might try to convince you that refusing these tests will make you look guilty, but that's not true. The prosecution can't use your refusal to take voluntary tests as evidence of guilt. The breathalyzer question. Will you take a breath test? This question is about the preliminary breath test, or PBT, which is different from the official breath test at the police station. The preliminary breath test is usually administered roadside using a handheld device. Like field sobriety tests, this is voluntary in North Carolina. The officer will often present this as a way for you to prove that you're not impaired. They might say something like, "If you're not drunk, you shouldn't have any problem taking this test." This is a manipulation tactic designed to make you feel like refusing the test is an admission of guilt. The preliminary breath test is not admissible in court to prove your blood alcohol content in North Carolina. However, the results can be used to establish probable cause for arrest. If you blow below the legal limit, the officer can still arrest you if they believe you're impaired by alcohol, drugs, or a combination of both. The problem with the preliminary breath test is that it can cause false positive. These handheld devices aren't as accurate as the machines used at the police station. They can be affected by things like mouthwash, breath spray, recent vomiting, or certain medical conditions. A false positive can lead to an arrest even if you're not impaired. Some people think that taking the preliminary breath test and passing it will end the DWI investigation. This is rarely the case. If the officer's already decided that you're impaired, a breath test result below the legal limit won't change their mind. They'll simply conclude that you're impaired by something other than alcohol. The lying question. Are you being honest with me? This question usually comes after you've answered several other questions. The officer will ask something like, "Are you being honest with me?" or "Is there anything else you want to tell me?" This is designed to make you second guess your previous answers and potentially provide additional incriminating information. This question creates psychological pressure. It implies the officer doesn't believe your previous answers and gives you a chance to come clean. Many people interpret this as an opportunity to be more forthcoming, thinking that honesty will help them in their situation. The reality is that this question is designed to get you to contradict your previous statements or provide additional incriminating information. If you've already said that you haven't been drinking and the officer asks if you're being honest, you might feel compelled to admit to having a drink or two. If you've said you're coming from home, you might feel pressured to admit that you were actually at a bar. Any changes to your story can be used against you. The prosecution can argue that you were initially dishonest, which damages your credibility. They can use any additional admissions as evidence of impairment. The best response to this question is to politely state that you've been honest and that you'd like to exercise your right to remain silent. You don't need to justify your previous answers or provide additional information. The empathy question. I'm just trying to help you out. Officers are trained to build rapport with suspects and create a false sense of security. They'll often say things like, "I'm just trying to help you out here," or "I'm on your side, but I need you to work with me." This is designed to make you feel like the officer's looking out for your best interests. The truth is, it's the officer's job to investigate suspected crimes and make arrests when appropriate. They're not your advocate. They're not trying to help you avoid charges. Everything they do during a DWI stop is designed to gather evidence that can be used against you in court. When an officer says they're trying to help you, they're usually setting up a false choice. They might say something like, "Look, I can tell you've been drinking, but I don't think that you're drunk. If you cooperate with me and take these tests, I might be able to let you go with a warning." This is almost always a lie. If the officer already suspects you're impaired, they're not going to let you go, regardless of how you perform on the field sobriety test. They're going to use your performance on these tests as evidence to support their arrest and their subsequent charges. I've never seen a case where someone was pulled over for suspected DWI, admitted to drinking, agreed to take field sobriety test, and then was released without charges. Once the officer suspects impairment, the investigation moves forward toward arrest. The confusion question. Do you know why I stopped you? This question serves multiple purposes. First, it tests your mental clarity and awareness. If you seem confused about why you were stopped, that can be used as evidence of impaired driving. The officer already knows why they stopped you. They don't need your input to establish the reason for the stop. If you were speeding, they have radar or pacing evidence. If you were weaving, they have their observations. Your admission doesn't help your case, but it can certainly hurt it. Some people try to be clever and say that they don't know why they were stopped, thinking this will make them seem less guilty. But if the officer has obvious evidence of a traffic violation, claiming ignorance can make you seem impaired or dishonest. The safest response is to politely decline to answer. You can say something like, "I'd prefer to exercise my right to remain silent." This doesn't provide any evidence against you, and it doesn't make you seem evasive. The nervousness question. Why are you so nervous? Being pulled over is stressful for everyone, but officers are trained to interpret nervousness as a sign of guilt or impairment. They'll often comment on your nervousness and ask why you're so nervous. This question's problematic because there's no good answer. If you say you're not nervous, the officer can testify that you seem nervous but were unaware of it, suggesting impairment. If you admit to being nervous, they can argue that you were nervous because you knew that you were impaired. Normal nervousness during a traffic stop is not evidence of impairment. However, excessive nervousness or the inability to control your nerves can be used as evidence that you're impaired. The officer's trying to get you to provide an explanation for your nervousness that might implicate you. Some people try to explain their nervousness by saying things like, "I'm nervous because I've been drinking," or "I'm nervous because I have drugs in the car." These statements are obviously problematic because they provide direct evidence of criminal activity. Others try to provide innocent explanations like, "I'm nervous because I've never been pulled over before," or "I'm nervous because I'm late for work." While these explanations seem harmless, they can still be used against you. Prosecution can argue that someone who's sober and innocent shouldn't be that nervous about a routine traffic stop. The cooperation question. Are you going to cooperate with me? This question is designed to frame the interaction in terms of cooperation versus non-cooperation. The officer wants you to feel like you have to choose between being cooperative and being difficult. Most people will want to be seen as cooperative, so they agree to answer questions and perform tests. The problem is that the officer's definition of cooperation is different from yours. To them, cooperation means doing everything they ask, including answering incriminating questions and performing field sobriety tests. To you, cooperation probably means being polite and following lawful orders. You can be cooperative without answering questions or performing tests. You can be polite, provide your license and registration, and follow lawful orders without incriminating yourself. Exercising your constitutional rights is not being uncooperative. The officer might try to make you feel guilty for not answering questions. They might say things like, "If you're innocent, you shouldn't have anything to hide." This is a manipulation tactic. Innocent people exercise their constitutional rights all the time, and there's nothing wrong with that. The consequences question. Do you understand what's going to happen? This question is usually asked after you've been arrested, but before you've been asked to take a breath test at the police station. The officer will explain the consequences of refusing the test and ask if you understand what's going to happen. In North Carolina, if you refuse to take a breath test after being arrested for DWI, your license will be suspended for 1 year. This is called the implied consent law, and it's found in North Carolina General Statute 20-16.2. The officer is required to read you your implied consent rights and ask you if you understand them. While this might seem like a straightforward informational question, it's actually designed to ensure that any refusal to take the breath test is knowing and voluntary. If you say you didn't understand, the officer will explain the consequences again. If you do understand, they'll ask if you're willing to take the test. The decision of whether to take the breath test is complicated and depends on specific facts of your case. If you take the test and blow above the legal limit, that evidence can be used against you in court. If you refuse the test, your license will be suspended, but the prosecution won't have breath test evidence to use against you. This is one of the few questions you'll be asked during a DWI stop that you'll actually need to answer. The officer needs to know that you understand your rights before you make a decision about the breath test. However, you should still be careful about how you respond to follow-up questions. How to respond to these questions. Now that you understand the purpose behind these trick questions, let's talk about how to respond to them. The most important thing to remember is that you have constitutional rights and you're allowed to exercise them. You have the right to remain silent under the Fifth Amendment. This means that you don't have to answer questions that might incriminate you. You can politely tell the officer that you'd prefer to exercise your right to remain silent. You also have the right to refuse to perform field sobriety tests. These tests are voluntary in North Carolina, and you can politely decline. The officer might try to convince you that refusing will make you look guilty, but that's not true. When exercising your rights, it's important to be polite and respectful. Don't argue with the officer or become confrontational. Simply state that you'd prefer to exercise your right to remain silent or that you'd prefer not to take the tests. Here are some phrases you can use. Officer, I'd prefer to exercise my right to remain silent. I'd prefer not to answer any questions. I'd prefer not to take any tests. I understand my rights and I'd like to speak with an attorney. Remember, you will need to comply with lawful orders. You need to provide your license, registration, and insurance when asked. You need to get out of the car if ordered to do so. You need to submit to an arrest if the officer decides to arrest you, but you don't need to answer incriminating questions or perform voluntary tests. What happens after you exercise your rights? Some people worry that exercising their rights will anger the officer and make the situation worse. While it's true that some officers don't like it when people exercise their rights, you can't let that stop you from protecting yourself. If the officer was going to arrest you anyway, exercising your rights won't change that, but it will prevent you from providing evidence that can be used against you in court. If the officer wasn't going to arrest you, exercising your rights shouldn't change that either. The prosecution can't use your refusal to answer questions or perform voluntary tests as evidence of guilt. They can't tell the jury that you refused to cooperate or that you acted suspiciously. Your exercise of constitutional rights is protected. However, if the officer believes that they have probable cause to arrest you, they will arrest you regardless of whether you answer questions or take tests. The arrest might happen sooner if you exercise your rights, but it was going to happen anyway. The legal reality of DWI stops. Here's something most people don't understand about DWI stops. The officer usually makes the decision to arrest you very early in the interaction. By the time they're asking you these trick questions, they've already decided that you're impaired. The questions aren't designed to determine if you're impaired. They're designed to gather evidence to support the arrest that they've already decided to make. This is why there's no good answer to most of these questions. The officer isn't looking for information that will exonerate you. They're looking for evidence that will convict you. North Carolina courts have recognized that DWI stops are inherently coercive. In State v. Knoll, the North Carolina Supreme Court acknowledged that people stopped for DWI are often not free to leave and may not understand their rights. This is why it's so important to know your rights before you're in the situation. Common mistakes people make. The biggest mistake people make during a DWI stop is thinking that honesty will help them. They believe if they're truthful about their drinking, the officer will appreciate their honesty and treat them more leniently. This almost never happens. Another common mistake is thinking that performing well on field sobriety tests will prove they're not impaired. These tests are designed to detect impairment, not prove sobriety. Even people who are completely sober can fail these tests under the right circumstances. People also make the mistake of thinking that they can talk their way out of a DWI arrest. They'll try to explain their situation, make excuses, or convince the officer that they're not really impaired. This rarely works and usually just provides more evidence for the prosecution. The importance of legal representation. If you're arrested for DWI, it's crucial that you contact an experienced attorney as soon as possible. DWI cases are complex and the consequences can be severe. You need someone who understands the law and can protect your rights. An experienced DWI attorney can review the evidence against you, including the officer's questions and your responses. They can determine if the officer followed the proper procedures and if your rights were violated. They can also negotiate with the prosecution and represent you in court. Many people think that they can handle a DWI case on their own, especially if it's their first offense. This is usually a mistake. The law is complex and there are many potential defenses that a layperson might not know. Understanding the stakes. A DWI conviction in North Carolina can have serious consequences. You could face jail time, fines, license suspension, increased insurance rates, and a permanent criminal record. For some people, a DWI conviction can affect their employment, professional licenses, and even their ability to travel to other countries. The stakes are too high to take chances. If you're facing DWI charges, you need to take them seriously and get professional help. An experienced attorney can help you understand your options and fight for the best possible outcome. Moving forward, if you've been arrested for DWI, don't panic. The arrest is just the beginning of the legal process. You'll have opportunities to challenge the evidence against you and present defenses. But you need to act quickly and get the right help. Remember, the prosecution has to prove you're guilty beyond a reasonable doubt. They have to prove that you were driving while impaired or that your blood alcohol content was 0.08 or higher. This isn't always as easy as it sounds, especially if you've exercised your rights during a stop. Now, what I've shared with you today about these trick questions is just the foundation. Understanding these questions and knowing how to respond to them is critical, but it's only the first step in protecting yourself. The real key to beating a DWI charge lies in understanding the specific defense strategies that can be used in North Carolina courts. And that's exactly what I'm going to cover over in my next video, How to Beat a DWI in North Carolina, 10 Proven Defense Strategies. This isn't theory. These are actual strategies I've used successfully in courtrooms across North Carolina to get charges reduced or dismissed entirely. I'll walk you through each strategy, explain how it works, and show you real examples of how these defenses have saved my clients from conviction. See you over there. If you're facing DWI charges, or if you just want to be prepared in case you ever find yourself in this situation, the next video could be the difference between a conviction and walking away free. The strategies I'm going to share aren't commonly known, but they're incredibly effective when used correctly. Don't let another day pass without knowing how to protect yourself properly. Click that link, watch that video, and arm yourself with the knowledge you need to fight back. I'll see you over there. And remember, arrested doesn't mean guilty.